Good morning.
Good morning.
Good morning.
Welcome to a Zoom oral argument session at the Fifth District Court of Appeal. I'm Judge Eisnagel. I'm joined on this panel today by Judge Harris and Judge Kilbane. Please remember to turn off any electronic devices you have, cell phones, anything like that, that might interrupt our argument today. And we have here on the docket before us case number 23-3295. Tehran versus State. Forgive me if I mispronounced the name there. Tehran versus State. Is that correct?
That's correct.
All right. If counsel for appellant, if you want to let me know how much time you'd like to save for rebuttal.
5 minutes.
5 minutes. Okay. I'll attempt to remind you. It's primarily your responsibility to watch the clock, but I'll make an effort to remind you once we get there. And with that, counsel for appellant, you are recognized.
Good morning, Your Honors. My name is Michael Reiter, and I represent Montserrat Theron. I'd first like to start out by indicating a general statement that most of the rulings, if not all of the judge's rulings below, denied my client the ability to defend himself. Specifically, with regard to Dr. Crown, the judge cited Haddon as its authority to deny him the ability to testify to a number of hypothetical questions. I think it's unfair for the state to be permitted to bring in similar fact evidence, which I'll discuss later on another issue, and say to my client, well, you can't bring in an expert to debunk that information. If Dr. Crown were permitted to testify, he would have indicated that that is very unreliable evidence. 35 years from a child's testimony, confabulation kicks in. They hated my client. They had reason to lie. They don't come forward until such time as they see 6 newspaper articles. Corporal Rodriguez sent out Interpol to try and corroborate their statements that they spoke to somebody, or many inconsistent statements. Problem is that my client was denied the ability to speak to the jury to say why that information is unreliable. Secondly,
why can't you make those arguments to the jury? Why do you need an expert to make those arguments?
I don't think a jury understands how children after 35 years can remember things accurately based on things happening in their life. That's the reason why we have experts, is to explain to jurors why those things don't occur. Not only that, with regard to the pedophile issue, the state argued in closing argument that my client trained his child and manipulated his child. Dr. Crown would have testified that that doesn't happen. You have to have regular access to a child to be as dysfunctional as she was. My client saw this child maybe once to twice a year, but yet the state argues to the jury that he's training her, and my client doesn't have a right to defend himself with an expert testifying why that doesn't happen. In addition to that, the judge in the rape shield argument, first of all, case law indicates that rape shield deals with consent. We never contested on consent on the child. We weren't bringing that up. We're trying to show through the expert that this child was dysfunctional, that she was aggressive, that she had reason to lie. She wanted to be the victim and not the perpetrator in this particular case. She was being chastised by her aunt. She's being chastised by her uncle. She's being chastised by her grandparents. She wanted to be the victim here. By denying my client for the rape shield argument, the expert, other witnesses were unable to testify to the functions of how this child was acting. For example, although I agree with the state, Tehran had the ability to testify that she had went to the bathroom, was trying to constantly pull on his penis and pull his pants down. But he is the defendant in this case where his credibility is questionable. But the grandmother and the grandfather were not permitted to testify to what they saw and what they heard his child do. Therefore, what the expert would have, based upon everything he read, the depositions, and the people he spoke to, he would have testified that based upon masturbation on a regular basis, the dysfunction of a child, pulling down pants, pulling on penises, this child was trained by somebody who had regular access, not by somebody who only met with this child once or twice a year. So my client was unable to defend himself with that expert. With regard to the similar fact evidence situation, the court stated in its order that neither remoteness nor geographical favored exclusion. Well, what the court did not do is it didn't consider some of the impeaching, well, it didn't refer to any of the impeaching evidence. For example, Corporal Rodriguez sent Interpol out to corroborate the fact that these two individuals had spoken to other people. Interpol could find nobody to corroborate that statement. During the depositions, which the judge said he read, major inconsistencies. When I would question the individuals, they would give me one answer. When I talked to the state attorney's office, they'll give another answer. When I talked to the statement for the police, they gave a different answer. the court never considered any of the inconsistencies with regard to admission of that civil effect evidence. The only thing the court kept out was the actual sexual intercourse by my client with one of the witnesses. For example, when I asked one of the witnesses about oral sex, she goes, "What about oral sex? There was no oral sex. I never told that to the police." But when the state questions her, she changes the testimony. I think the court should have at least considered the fact of those years that have gone by, and there was no case I could find where 35 years have gone by with the motive that these people have had against my client. She hated him because he belittled them, he harassed them, he divorced their aunt. They had, by the words of themselves, they hated this man. And they don't come forward until such time as they see these news articles. There was a definite motive for these people to lie. And an expert would have been able to testify why confabulation in this particular case would show that those statements are unreliable. Of course, you're not allowed to come in. With regard to the hearsay, I'm concerned about the fact that the court did not make mention of the fact that the father had undue influence with regard to this child. When this first came out, it wasn't the mother who took the child upstairs. It was the father who took the child upstairs. It wasn't recorded. We have no knowledge of what took place with regard to that conversation. When it came to the nanny cams, it was the mother who did the questioning of the child, not the father, although he was there for one of them. So my point being in this particular case is those particular nanny cams should not come in because you had already a CPT tape. You already had the testimony of the child through depositions. That was cumulative evidence that was more prejudicial than it was probative. It had no value other than to bolster the testimony of the child. I think that was hearsay evidence that was the probative value was far outweighed by the prejudice to my client. With regard to fundamental error, there were two witnesses of the state. The CPT individual testified that not only did she find the child credible, but a team found the child credible. And Corporal Rodriguez indicated that with regard to the child, he was, let me back up. With regard to the CPT operator testifying, defense counsel did not object on that issue. With regard to the police officer saying that he had never seen anything like this video, was objected to and sustained by the state. But as important is, he was asked the question with regard to the father, whether there was any evidence that he had committed any offense. He went on to explain without question that the father was a good father and a good husband and had no evidence. He bolstered the character of the father when we were arguing that one of two things happened. Either the child is lying or somebody else, probably the father, who had general access to the child. That was fundamental error. The judge should have stopped the case and ended a mistrial right away. I'll reserve the rest for rebuttal.
Thank you, counsel. You have 13 minutes and 2 seconds for rebuttal. All right, counsel for the appellee, you're recognized when you're ready.
Good morning. My name is Robert Bradford, and I represent the state of Florida in this matter. I think it's important. Counsel made mention of the hypothetical questions that would explain his defense, but I think it's important to keep in mind the actual question, which is on page 1219 of the trial transcript. I'm sorry, the record transcript, the record on appeal. The question was, assume someone molests one or two children back in 1993 and then goes 35 years and is accused of molesting another child. Does that person qualify as a pedophile under the DSM-5? I don't think there's any relevance to that. I mean, he's not charged with being a pedophile. And the question presupposes or assumes that he did molest the two nieces in Puerto Rico. So I think the fact that he never evaluated LN, he was kind of left with this situation. Essentially, the appellant wanted his trial to be more than a credibility contest between himself and maybe his wife and LN, the victim. He was going to do that by bringing in the expert witness to advance these theories, but these theories were being put forth by an expert who hadn't treated a sexually dysfunctional patient in over 30 years. I mean, by the time of trial, his practice was primarily treating brain injuries, stroke victims, dementia patients, that sort of thing. He hadn't even practice, I think, clinical therapy in 20 years. But basically what he wanted to say, or what the appellant wanted him to say, is that LN, the victim, may have been abused because of the way she was acting, and she may have been abused by her father. But the only evidence we have of that is that he had access and opportunity, but that LN may have been protecting him by falsely accusing somebody else. So the court is, I mean, the question or the defense is asking the jury to stack inference upon inference upon inference to get to a conclusion, and that simply is not permitted. Dr. Crown, even as far as his false accusation, initially testified on direct examination that he had seen it 30 years in the past. He had seen it 20 to 25% of the time in his cases. But then he, on cross-examination, when he was confronted with a prior inconsistent statement and lesser numbers, I think it was 10 to 15%, but I'm not certain. He basically backed it all the way down to infrequently and wouldn't even put a number on it. So as far as reliable, it simply wasn't. 702 requires three things, the second of which was simply not satisfied here, and that, of course, being that there has to be reliable principles and methods. The reliable, and the court did talk about this, although the court talked about it in terms of established theories and generally accepted, general acceptance in the scientific community. But under VTLO, and those kind of sound like fry words, but under VTLO, those factors are used in considering admissibility under Daubert. So, and of course, the Daubert's preliminary assessment of the scientific validity of the theories is just, it's not there. I mean, the Dr. Crown couldn't offer anything to allow the court to make that preliminary assessment that it was scientifically valid. Even defense counsel acknowledged that he couldn't say that the appellant wasn't a pedophile. And the best he could do with regard to this confabulation theory on two sisters who happened to have it at the same time is that it's usually it was basically speculation on his part, because he usually sees it in dementia patients. As far as the similar fact evidence and the child hearsay, the appellant's argument is basically trying to couch an abuse of discretion argument inside a procedural issue. And I'm not sure if that was intentional or due to the burdens of proof, but there's no authority, precedent, rule, statute that says a court has to address every factor affecting or potentially affecting admissibility. As far as the similar fact evidence, there are specific factors that set forth in the statute and in Townsend, and the court looked at that, and it was very detailed in its order and its recitation at the hearing as to what it considered. It read the deposition transcripts. It considered all the hearing testimony. It had looked at the recordings as far as the child hearsay statements. But as far as the similar fact evidence, he said it was substantially similar and was, if not identical. And the court did exclude at least two things, I think, the penile vaginal intercourse and the breast licking, because those weren't similar at all. And so he considered all these things. He just simply did not address everything that preponderates against admissibility, although he was very detailed. And the Townsend court even talked about, when trial courts get reversed is when they just say it's admissible, or they just track the boilerplate language of the statute. You have to make some pretty specific findings, which this court did. He talked about the similarity as far as the approximate ages of the victims, the familial relations,
Counsel, was it proper for Sergeant Rodriguez to testify that the interview was, quote, the most powerful thing I have ever seen?
No, He probably shouldn't have said that, and the court effectively said, I think he said some sort of move on. Let's get away from this. Effectively, I think he sustained the objection, but then there was no motion for a mistrial, which makes it not fundamental, which makes it an unpreserved error, and I don't think it rises to the level of a fundamental error because it's not. It's hard for me to accept that a jury that otherwise was not going to convict decides to convict because this detective said that was a pretty powerful video, the most powerful I've seen.
Could the jury observe the video themselves
Yes.
and make their own conclusion about how powerful it was?
Yes, absolutely.
Was this comment in any way raised in closing argument?
I don't recall that it was. Counsel can correct me if I'm wrong, but I don't recall it being a part of the argument at closing. In addition to that, the geographical proximity with respect to the similar fact evidence and the convenience factor as far as him not having to go out and find this victim, as well as the manner of abuse. So the similarities were there. They were addressed by the judge. And with respect to the child hearsay, it's kind of the same thing. It's all about child hearsay is all about reliability and a trustworthy source. And I think every indication was that it was correct. And that's even if that's not the case. The fact that the similar fact evidence was presented is, I think, makes any error associated with the child hearsay harmless. Because again, you're talking about reliability. That's what that whole issue was about. And LN, the victim, was consistent throughout her recitations, and again, it was very similar to what happened in Puerto Rico with the other nieces. Your Honor asked me about Detective Rodriguez, and the only other thing I wanted to talk about, I guess, was the vouching issue. There was 3 incidents. None of them were preserved for appellate review. There was no objection to the competent and credible comment by the forensic interviewer. And then also when I think it was Detective Rodriguez that said LN's dad was a good dad and he had absolutely zero evidence, inculpating him in this incident. Both of those didn't receive objections, but as far as fundamental error, I think the invited error doctrine really takes care of that because in this case, the defense counsel was pressing the forensic interviewer on why she didn't ask LN during the interview about her ability, the 7-year-old girl, about her ability to distinguish between right and wrong, or I'm not sorry, not right and wrong, but the truth and lies. And he pressed her basically about why didn't you do that? He just kept in, why didn't you do that? And she answered the question. And so therefore it was definitely an invited error. They didn't do that because they thought she was competent and credible. And again, with respect to the father and zero evidence, counsel had asked about what evidence Detective Rodriguez had about him. And I think specifically asked about whether he had shown LN any pornography while in Massachusetts. And that was, so that was also an invited error. I mean, he just answered the question. No, we had no evidence of his inculpability, and just every indication he was a good dad. So I don't know if the court has any other questions for me. There was the one other issue with the JOA, but I think it was pretty clear in the answer brief what the state's position is on that issue. So unless there are any further questions, I would rely on further argument in my brief and ask this court to affirm the judgment and sentence in all respects.
Thank you, counsel. All right, counsel for appellant, you have 13 minutes and 2 seconds left.
Thank you, Judge. It is paramount in every case that a defendant have a right to defend himself. Without that right, due process means nothing. Let me point out that with regard to Dr. Crown, there are issues when you're dealing with sexual assaults of children that many people don't understand. The psychology of it, the physicalness of it, time frames of it, and that's why an expert is necessary. There is nowhere within the judge's ruling that he finds that Dr. Crown's experience is insufficient. No mention whatsoever about it. He's been a doctor. He started the sexual assault in Miami. He's the one who created that particular foundation. He's been doing it for 35, 40 years. With regard to his testimony regarding those children on confabulation, it is important to understand to a jury how time and attitudes and experiences in life can change a child's memories. It's affected constantly. The judge relies strictly on Haddon and Daubert. Well, if you look at the brief, there are cases permeated throughout that brief indicating that even Daubert says when it comes to psychological testimony, it's flexible. A number of cases indicate it's almost impossible to utilize a scientific method for the admission under Daubert for psychological testimony. And that's why all those cases say you must be flexible. There was no reason that the judge should not allow Dr. Crown to testify to the issues that he was going to on the hypotheticals. He testified at the depositions. All of the information he had testified had read. He read all of the depositions. He spoke to witnesses. He had done research. He was, with regard to pedophile, I agree that if we were trying to introduce the idea that our client was not a pedophile or that he was a pedophile, the courts have indicated that's not permitted. But that was not the reason for the introduction of explaining how children who are trained or manipulated, as the state argued, is not done by somebody who only sees them once or twice a year, but is done by someone who is done over time. That was the purpose of that particular testimony. And a jury may not have the knowledge with regard to how children are treated and how they become that type of situation. With regard to the sexual dysfunction of the child, the grandmother and the grandfather in this particular case basically were unpermitted to testify because they were going to testify to what they had seen and heard from this child over time. They would have corroborated Mr. Tyrone's testimony with regard to the masturbation, pulling down his pants, pulling on penises. They didn't have the same credibility that Mr. Tyrone had because they were the child's grandparents. They had there was not a bias on their part for either party, either mother or the aunt or uncle. So they should have been permitted to testify. With regard to the fundamental error, again, the briefs are permeated with situations where the credibility of any witness is left to the jury, not to the law enforcement officers who carry a great weight with jurors. By Rodriguez indicating, oh, the father is a good father and a good husband. He didn't even know this man. Where did this come from? That jury is going to listen to him because he was the primary investigator on this case. Also, with regard to the, as you suggested, did the jury get to see this video? Maybe so, but again, what if we don't know? What if their intent or their version of that wasn't as strong as the officers? And now they compare what the officer said, the strongest one I've ever seen. Well, they haven't seen any others, but they'll take his word for it, that this is one of the worst ones they've ever seen, most impounding on them. So whether they saw the video or not does not reflect the indication by Officer Rodriguez. The similar fact evidence should not have come in. This is a situation where even regarding one of the witnesses who testified, he did absolutely nothing to this person other than she took off her shirt and ran out. He didn't do anything to her, yet she was allowed to testify to things that he didn't even do. With regard to Ellen's testimony, state says she was consistent. If you look at her testimony on the stand as well as the deposition, she was as big as you can get. Maybe it happened. It could have happened. I'm not sure if it happened. Most of her testimony was not adamant about what in fact happened. So when Dr. Crown was testifying on a hypothetical with regard to her testimony, her activities, the jury would get to hear from him regarding how a child in those type of circumstances, if they're protecting another individual, how they might react. Or if in fact that she was mad at being chastised. Maybe she was mad at the fact that none of the males would let her pull his pants down or touch his penis. So she wanted to be the victim in this particular case and lied about it. That information from Dr. Crown was not permitted to come in. And under the circumstances, Judge, I would request that this court reverse and send back for new trial.
Okay, thank you, counsel. All right. Having heard the argument, we appreciate counsel's time and attention today. And with that, this court is in recess. Thank you very much.
Thank you.